A white SUV hit the gravel hard, dust exploding like a challenge. Before the dust even settled, she was out of that vehicle, moving with the kind of urgency that comes from someone who never accepts the word no. Karen Voss, bright pink blazer, perfect golden curls, pearl earrings, looked less like a neighbor and more like she had come to reclaim something that was never hers. She grabbed the iron gate and shook it hard. The lock didn't budge, and that's when she realized something terrifying. For the first time in her career as HOA president, there was a boundary she couldn't cross. But what she didn't know was that locked gate was about to expose everything she had been hiding for years. Behind that gate, on 40 acres of private land, Evan Mercer stood with coffee in one hand and survey papers in the other. He watched the chaos unfold without flinching. Evan wasn't some angry neighbor. He was a surveyor, someone who had spent decades understanding property lines, boundary disputes, and the legal frameworks that protect land ownership. He knew something most people never learn: records don't lie. People do. Retirement was supposed to be quiet. After spending his career measuring boundaries for other people, Evan wanted one thing: space, privacy, and a slower life where he could just exist without conflict. He found exactly that when he discovered the 40-acre parcel north of Callaway Ridge subdivision. It was pristine, quiet, and most importantly, completely separate from the HOA's jurisdiction. Evan checked everything before he bought it. He pulled the plat maps himself. He reviewed the deed chain. He studied the covenants, conditions, and restrictions, the CCRs, that defined what the HOA actually controlled. The land was clean. No covenants tying him to Callaway Ridge. No easements giving the HOA rights to his property. No jurisdictional boundaries extending onto his land. It was exactly what he needed. When he installed the gate, it wasn't a statement. It was security. He wanted privacy, something every homeowner deserves on their own property. He didn't know he was about to discover that Karen Voss couldn't tolerate any boundary she couldn't command. The trouble started almost immediately. Within days, Karen drove up to the gate, photographed the lock like it was a crime scene, and posted the image in the HOA's private community channels. Not to his face. Not in a formal communication, but in a forum where she could shape the narrative before Evan even knew what was happening. She called it a safety issue. She called it a violation. She called it a threat to the community. But when Evan pulled the county records and checked the jurisdictional boundaries for the 100th time, nothing changed. The line was still exactly where it had always been. Her authority ended at the subdivision boundary. His property was beyond it. A written demand arrived, citing rules that only applied inside the subdivision and pretending they somehow reached onto private land outside her jurisdiction. When Evan asked for the recorded document that gave the HOA authority over his property, a simple, legal question, no response came. Instead, Karen escalated. She sent an attorney's letter, all polished language and official letterhead, designed to intimidate someone who didn't know the difference between authority and performance. But Evan knew. He had built his entire career on the difference. What Evan saw clearly was Karen's pattern. She didn't build cases on law. She built pressure on assumptions. She believed that if she sounded confident enough, if she repeated the claim enough times, if she involved enough people and enough official-sounding language, eventually someone would surrender just to make it stop. It was a strategy that had worked for her before. It didn't account for someone like Evan. The campaign intensified. Karen used every tool at her disposal. The clubhouse corkboard became her message board. The HOA newsletter became her propaganda platform. Board meetings became opportunities to establish her narrative in front of an audience of residents who trusted her more than they trusted their own ability to verify her claims. She repeated the same claim over and over. The gate created a safety hazard. The northern boundary was a community issue. His property somehow belonged in their jurisdiction because she said so. Simplified maps started appearing, maps that conveniently left out the actual boundary lines showing where the HOA's authority truly ended. Support forms circulated through the neighborhood asking residents to sign petitions backing the board's position. Most people who signed didn't realize they were signing away their own understanding of property rights. They trusted the board. The board president said it was a safety issue. It must be a safety issue. Then the campaign crossed a line from manipulation into something worse: trespassing. Two board members appeared near Evan's back fence, photographing his property from angles that put them on his land without permission. They stepped through a damaged section of old fencing, his fencing, on his property, and stood there posing for photos as if they had every right to be there. Evan photographed everything: the footprints in his soil, the gap in his fence, the board members standing where they had no authority to stand. He saved every notice, every map, every board memo, and every picture, because Evan understood something Karen had clearly clearly forgotten. Documentation is power. Then came the moment when everything shifted into something genuinely dangerous. Karen filed for a temporary injunction. No more neighborhood pressure campaign. No more letters and phone calls. Now it was legal. Now it was official. Now it was real. The injunction claimed the gate blocked emergency access to the property. The injunction claimed it created a safety hazard. Those aren't small allegations. Those are the kinds of claims that can swing a judge's opinion if they go unanswered. This wasn't petty HOA politics anymore. This was a legal battle with stakes that mattered. And Evan knew he needed help. He called Joanna Hargrove, a real estate attorney known for handling boundary disputes in the county. When Evan walked into her office with his file, years of documentation, every map, every record, every photo, every email, Joanna reviewed it with the kind of calm that only comes from years of watching bluster collapse under the weight of actual evidence. She listened as Evan explained the situation, and then she said something that changed everything. She has no case. The safety claim was the only piece that deserved any attention at all, and even that had a foundation made of sand. Karen had no county engineer report. She had no emergency services review. She had no recorded right-of-way giving the fire department or ambulance services access through his property. She had a theory. She had a loud voice, but she had no documentation. She had no proof. She had no authority. Meanwhile, Evan had something Karen didn't. He had built the record the right way. He pulled the certified plat map, the official document filed with the county showing exactly where property boundaries existed. He gathered the CCRs, the official covenants that defined what the HOA could and couldn't do. He obtained the county recorder's confirmation that his property carried no liens, no easements, no jurisdictional ties to Callaway Ridge. He found the original county parcel map showing his 40 acres as completely separate from the subdivision. And then he found something that would matter most in the courtroom, the original 1999 survey record he had filed years earlier, with his own signature on it, documenting the boundary line with professional precision. Every document matched. Every boundary line aligned. Every piece of evidence pointed to the same conclusion. Karen Voss had no authority over Evan Mercer's property. The gate was his right. The boundary was his right. The property was his right. But there was more. Evan reached out to former residents of Callaway Ridge, and what they told him revealed a much darker pattern. A widow had been fined $500 for hanging a wind chime. The homeowner said it was a noise violation. The widow said she was being silenced because she asked questions about the HOA budget. A young couple was pressured to remove a basketball hoop from their driveway. The HOA said it violated community standards. The couple said they had seen a board member's boat trailer sitting in full view all summer without a single fine. Why the selective enforcement? Why did some residents get citations while others got passes? The more Evan investigated, the clearer the picture became. This wasn't about safety. This wasn't about community standards. This was about control. Karen Voss used fines, warnings, and selective enforcement to keep residents quiet and compliant. The wind chime fine had a purpose: intimidate residents into silence. The basketball hoop pressure had a purpose: establish that the HOA could make rules and enforce them capriciously. The boat trailer parked without consequence had a purpose: show that if you were on the board's good side, you could do whatever you wanted. Evan's file wasn't just a defense against Karen's injunction anymore. It was a mirror showing exactly how far Karen had stretched her authority. It documented a pattern of abuse. It exposed the corruption beneath the polished exterior. And when the hearing date was finally set, Evan had something Karen had never faced before: proof that survived outside her narrative. Proof that didn't care about her confidence or her authority or her loud voice. Proof that simply existed, permanent and irrefutable. The hearing room was small, quiet, and absolutely packed. Every seat filled. Every standing space taken. Word had gotten out. Residents of Callaway Ridge came to watch. Some came because they wanted to see if the HOA president could finally be challenged. Others came because they realized they might have been treated unfairly too. Some came just to witness what would happen when authority finally met its match. Karen arrived in her dark pink suit, her golden curls fixed perfectly in place, moving through the room like she still owned it. She still had that confidence, that absolute certainty that volume and authority would substitute for actual law. Her attorney stood beside her, ready to present the safety argument, ready to fight the injunction based on the claim that emergency services needed access to Evan's property. But the judge cut straight to the point. Before the arguments even started, before Karen's attorney could even fully develop the safety narrative, the judge asked a single question: do you have a recorded easement? Silence, because the answer was no. There was no recorded easement. There was no document, no legal right, no recorded claim to Evan's property in any county file anywhere. Joanna Hargrove then placed the certified plat map on the bench. She followed it with the CCRs, the official covenants that defined the HOA's boundaries. She placed down the county recorder's confirmation. And then, with the precision of someone who understands the power of a single document, she placed the original 1999 survey record on the bench. The one with Evan's signature. The one showing the boundary line with professional accuracy. The judge looked from one document to another, then back to Karen's attorney, then back to the documents, and something shifted in that room. The line that Karen had spent weeks pretending didn't matter was there in black ink, stamped by the county, certified as authentic, permanent. Evan confirmed that he had drawn the boundary years earlier, before any of this conflict existed. He was the professional. He was the expert. And the documents proved he was right. The legal fiction collapsed in real time. The injunction was denied. The HOA's rule citation was noted as inapplicable to Evan's property. The safety claim was dismissed for complete lack of proof. There was no documented right-of-way. There was no legal basis for the injunction. There was nothing but Karen's assumption that she could make a claim and have it believed. Karen's expression changed. You could see it happen. The confidence tightened into something brittle. The performance emptied out. What remained hardened into something cold and desperate. The look of someone realizing the audience can suddenly see the wires behind the illusion. For the first time, she left that room without the entire space moving with her. People stayed seated. People whispered. People looked at each other with new understanding. The county followed up with an official letter that made the ruling impossible to twist into any other narrative. Evan's parcel carried no HOA covenants, no easement, no jurisdictional rights for Callaway Ridge. The letter went into the county file. The HOA's own attorney warned the board that any further action could bring sanctions for frivolous filing. That meant the board itself could face legal consequences for wasting court time with a case that had no legal foundation. But here's what made this moment even more significant. The money Karen had spent fighting this battle came from the HOA Reserve Fund. Every homeowner in Callaway Ridge had helped pay for a legal battle their president had chosen and lost. The community money that should have gone to maintaining common areas, fixing roads, or improving facilities, had been spent on Karen's personal vendetta against someone who simply wanted to own his own property in peace. At the next board meeting, the silence was different. The questions finally came from people who had stayed silent for too long. Why was legal money spent on a claim the records never supported? Why were board members photographing private land without permission? Why had the board acted like a boundary could be created by confidence alone? Where was the transparency in how the reserve fund was being used? Why had residents never been told about this legal action before it happened? A new rule passed. It required independent legal review before any future filing. It meant the board could no longer go to court without getting an outside attorney to review the case first. It meant Karen could no longer use the power of her position to silence dissent through legal intimidation. Karen's control over the community didn't disappear overnight, but it started to crack. Board members who had always backed her started to ask questions. Board members who had signed off on her decisions started to distance themselves. And when the next board election came around, things changed. Karen's position on the board became vulnerable. New voices emerged. Fletcher Pewitt took a seat on the board and began asking the kinds of questions that should have been asked years earlier. Where did the budget go? Why were some residents fined and others weren't? How much of the HOA's power was actually legal? Delia Pewitt's old wind chime fine was eventually cleared from her record. The fee was returned. The violation was expunged. It was a small thing, but it meant something. It meant that people were finally looking at the decisions Karen had made and asking if they had been fair. On Evan's land, the orchard seedlings he had planted kept growing. The gate stayed locked, not out of anger anymore, but out of peace. The county line remained exactly where it had always been, not because Karen stopped claiming authority, but because the law finally made it clear that she had never had any. And none of this would have happened if Evan hadn't done one fundamental thing. He had documented everything. The moment Karen made her claim, he pulled the records. The moment she escalated, he saved every communication. The moment she became aggressive, he photographed every trespass. The moment she went to court, he had a file that proved she was wrong. This is the most important lesson from everything that happened at Callaway Ridge. Most HOA abuses stay hidden because most people never find out the truth. They believe the board president's confidence more than they trust their own ability to check the records. They assume that if someone sounds official enough, they must have authority. They don't realize that power without documentation is just performance. But here's what's crucial to understand. This story isn't unique. HOA abuse happens every single day in communities across the country. Residents get fined for things that don't actually violate the rules. Board members make decisions that benefit themselves while harming the community. Reserve funds get spent on legal battles that should never exist. Selective enforcement creates a two-tiered system where some residents are held to standards while others are ignored. And most of the time, it never gets exposed because most people don't fight back. Why? Because fighting back requires documentation. It requires knowing your property rights. It requires understanding that every HOA has boundaries, legal, jurisdictional boundaries, that limit their authority. It requires being willing to pull the records yourself instead of taking someone's word for it. It requires believing that the law exists for a reason and that you have the right to know what it says. What happened with Evan and Karen matters because it shows what's possible when someone refuses to accept false authority. It shows what documentation can do. It shows what happens when someone knows their rights and stands up for them. It shows that even HOA presidents, even people who have spent years building authority through confidence and repetition, eventually have to face the reality of recorded facts. The gate is still there. The boundary is still there. The records are still there. And the question that should be in your comments, the question that every homeowner should ask themselves is this: when someone claims power over your property, do they have a document or just a performance? Because the answer to that question might be the most important thing you ever know about protecting your own rights. If you own property, you need to know what covenants actually apply to your land. What easements exist in your deed? What jurisdiction does your HOA actually have? Don't assume you know. Check. Pull the records. Talk to a surveyor if you need to. Talk to an attorney if you're not sure. Because documentation isn't just a legal tool. It's power. It's protection. It's the difference between someone else's authority and your own rights. Thank you for watching this story. Please share it with anyone who owns property in an HOA community. They need to know that boundaries exist for a reason and they have the right to protect theirs. If you found this story valuable, please like and subscribe. There are more stories like this, stories of ordinary people standing up to institutional power and winning. These are the stories that remind us that the law actually works when you know how to use it. And sometimes all it takes is one person with the courage to say no, the documentation to back it up, and the determination to see it through.